So, counsel, welcome back. I'm glad you're here for the sentencing hearing. I've carefully read your sentencing memoranda, and I understand that defense counsel wishes to offer some live testimony as well. So let's hear from defense counsel.
Your Honor, I think that there is quite a bit for the court to consider in connection with imposing a sentence in this case. And from the outset, Your Honor, I think it's absolutely clear that in this case we have a very young offender. We have a defendant who was convicted 2 weeks into his 18th birthday. That this event took place 2 weeks earlier, these proceedings would have been in family court, and there would have been a whole panoply of social services involved in evaluating his conduct. Your Honor, the statute gives you the option and discretion of considering the same type of factors. And so because of that, we have taken a look at his background, his experiences, and his history, and have selected 3 witnesses, Your Honor, to come in to give you some information about him. One would be Mrs. Brown, whom which the defendant was living. The other would be a drug counselor, and the other would be a psychiatrist who has given an overview of the circumstances to help give the court some sense of the defendant's future risk for danger to the community.
Very good. Let me have you call whoever is your first witness.
Yes, Your Honor. The defense would call Miss Hope Brown.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. State your full name and spell your last name.
Hope Beatrice Brown, B-R-O-W-N.
Ms. Brown, can you please tell Judge Rakoff what you do for a living?
I'm a nurse.
And can you tell Judge Rakoff about your educational background?
Yes, it took me 8 years to finish school, but I went and got my certification and do my continuing education, so I stay certified.
Now, you see the young fellow sitting over there at the table with me?
Yes.
Who is he?
He's Jimmy.
Okay. Tell Judge Rakoff, how is it that you came to know Jimmy?
My daughter Melodie was dating him, and you know, was almost 18, so there's not much you can say. He seemed like a nice young man, and came a time when he had gotten kicked out of his home, and Melodie had come to me and said, you know, can he stay with us? So that was kind of how I met him and how he kind of came into our lives.
How long had he stayed with you at your home?
He was with us for about 6 months.
And was he living in your home at the time that he got arrested in this case?
Yes, he was.
Now, let Judge Rakoff know whether or not Jimmy had been in trouble, anything of that nature.
I mean, Jimmy, you know, it was clear that Jimmy had come from some troubled background. Melodie had shared a little bit about his family history. You know, that his father wasn't incredibly supportive, borderline abusive. And, you know, I had a past with drugs, but I've, you know, gone through treatment and recovered. And so I knew Jimmy was dabbling with drugs as well.
Did you ever know him to bring drugs into your home? No,
not that I was aware of.
Okay. And when Jimmy was at your home, did he work?
Yes.
Where did he work?
Jimmy, my understanding was that he was doing odd jobs, and what was really wonderful about him was that he didn't just come into our house and take. He really wanted to contribute. He wanted to be a part of the household, and so he would give me money when he could, a few $100s here and there.
But you had your concerns about Jimmy, didn't you?
Yes, I did.
What type of young man was he? Was he a leader, a follower? Were you worried about him?
Jimmy was really sweet, and he was good with Melodie, but he definitely wasn't a leader. Jimmy, Melodie probably wore the pants in that relationship, and so he was really kind of easygoing and would go along with, you know, whatever, even when we were doing things as a family. Jimmy kind of let us make the decisions and came along with it.
And are you telling the court that he was trying to become a part of your family?
Yeah, I think so. I do believe Jimmy was a part of our family.
Okay. Have you still been in touch with him after the case? Have you visited him? And
it's been really difficult, so no. You know, I know Melodie, just a bad situation. I haven't seen him since we found out what happened.
Okay. Ms. Brown, did you ever have a reason to be concerned with Jimmy's friends?
Yeah, I mean, one of the deals that I made with Jimmy and Melodie when he moved in was that he had to leave whatever behavior behind. So if there was any drug interaction before, if he was taking anything, he couldn't bring it into the house. And that also meant that he should not associate with any friends that he had had before.
And tell a judge about what you know about those friends, if anything.
You know, it kind of feels like a small community. So even though I didn't know of Jimmy before Melodie was dating him, you know, I got to kind of see and heard stories about the people he was running with. And I knew that that they were, you know, doing drugs or selling drugs, or it just seemed like a rough bunch.
In the few weeks up until the time of, at the time Jimmy was arrested, did you notice if the old friends were starting to come around? And was he getting phone calls or anything like that?
I didn't see any of his old friends, but we were getting some phone calls late at night. If I picked up, somebody would hang up. So there was definitely something going on out of the ordinary.
Is there anything that you would like to say to Judge Rakoff as a parent that the court may want to consider in making an assessment of the sentence to be imposed?
You know, I consider our family to be blessed, even though we've had financial hardships, we've had our share of ups and downs, but we were always a family. And that's something that I didn't see with Jimmy. You know, I don't think Jimmy had a good start. And I think that's part of the reason why we wanted to take him into our home. And when I first met Jimmy, he seemed a little broken. And yes, he's, you know, just turned 18, but, you know, Jimmy was a follower. And Jimmy wanted people to like him. Probably more so than always making the right decision.
Were you present for his trial?
Parts of it, yes.
So you know there was evidence that it was his idea to use a gun.
That's just not the Jimmy I know.
All right. Well, thank you so much.
Thank you.
All right, Mr. Rico, thank you very much. Let's call your next witness.
Your Honor, we call Miss Renita James. Watch your step.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do swear.
Please be seated, state your full name, and spell your last name.
Renita Jane, J-A-I-N.
Yes, Miss Jane. Good afternoon.
Good afternoon.
Okay. Can you tell the court what is it that you do for a living?
I am a licensed substance abuse therapist at Emmanuel.
Okay. And what is it that you do in your work capacity?
In my work capacity, I work with people who are addicted to drugs, and we work on a behavioral therapy structure. So we focus on changing the way people approach the use of drugs and the way they, the behaviors that lead them to use the drugs. And we believe that if you can get someone to focus on their motivations for using the drugs and realizing what the drugs are actually doing to them and the way the drugs are changing them, that they can take power and take control over their lives, and they can overcome their addiction, and they can lead fruitful lives.
How does age come into play with respect to therapy?
With adolescents, they are at a very susceptible age for becoming addicted to drugs of any sort. They are still developing their ability to make decisions, and it is a very difficult thing for a child whose brain has not developed in the prefrontal cortex enough to even be able to see ahead, to know the consequences of their actions, to be able to make those decisions about the drug that's in front of them, because they act very impulsively.
Okay. Now, you see this young fella sitting here in the courtroom?
Yes.
Tell Judge Rakoff how it is that you know him.
I met Jimmy Moran when he was 17 and a half years old. It was September, and I met him because Hope Brown had contacted me that her daughter had a new boyfriend, and she was concerned and worried that Jimmy might be involved with drugs. And when he came in, we actually did a drug screening, and he was clean. He admitted to me that he was a user, but not consistent. And when he came in, I noticed that he also had symptoms of depression and anxiety. And at our facility, we can do drug therapy if you're addicted. However, it was clear that Jimmy was not addicted, but he did show signs of other disorders. And so I wanted to have those evaluated in the proper setting so that he could get some help.
And I'm sorry.
Oh,
and was he
yes.
receptive?
Yes. Jimmy was very, very highly motivated to be clean and to be living a life that he felt was normal. Jimmy had a history of depression through his family. He came from an abusive home. He had actually been kicked out of his home, and he had several stressors, and so he was exhibiting depression and anxiety disorders. And those, I believe, were the root cause of his using the cocaine. I believe he was self-medicating to relieve the depression.
Last question. Did you ever have an opportunity to interview his parents? Were they receptive to meeting with you?
No, they were not.
Did you make an attempt to meet with them?
Yes.
Okay. I have no further questions. Thank you very much, Your Honor.
Thank you very much. Anything from the prosecutor?
No, Your Honor.
So thank you very much. You may step down.
Thank you.
All right, counsel, please call your next witness.
Thank you very much, Your Honor. The defense calls Dr. Bear.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated, state your full name, and spell your last name.
Alexander Baer, B-A-I-R.
Good morning, Dr. Bear. Can you tell Judge Rakoff what it is that you do for a living?
I'm a child and adolescent psychiatrist and a professor of psychiatry
Where?
at City Hospital.
Okay.
And how long have you been in your profession?
I've been on faculty and staff for 30 years.
And what do you do in connection with your clinical work?
Well, I have an active clinical caseload, kids, adolescents, and families that I see myself, and I supervise a number of residents in my training program on many of their cases.
And you see this young man seated here today?
Yes.
And who is he?
That's Jimmy Moran.
Okay, and how is it that you came to know him, and what work did you do in connection with knowing him and in this case?
I was asked to do a psychiatric evaluation of Jimmy understanding his clinical situation and his risk of dangerousness.
All right. Explain to Judge Rakoff what documents and interviews you conducted in connection with your evaluation.
Yes, Your Honor, I spent about 4 hours interviewing Jimmy. I reviewed all of his medical records, his school records, spoke with his school guidance counselor and special ed director. I spoke with Renita Jane, the drug counselor, with Ms. Brown, and with his mother and father.
And based upon that evaluation, did you form opinions about issues related to future dangerousness, risk assessment, and his overall psychiatric condition?
I did.
Okay, and will you share with us what those findings were?
Jimmy is the oldest of 3 in an Irish Catholic family. He has 2 younger siblings, 10 and 7. When he was very young, he was severely abused physically and emotionally by his father, who was prone to temper outbursts.
Did you ask his parents whether he was abused?
I did.
And what did they say?
Well, the father denied it and the mother confirmed it.
Okay. Go ahead.
Okay, so continue. Tell us about how those factors influence your ultimate findings.
Well, they're complicated by the fact that when he was young, he was diagnosed with a learning disability and cognitive slow processing speed, which means that he wasn't able to process information at a rapid pace. He was placed in special education from the 2nd grade on, and was noted in the psychological testing that I reviewed from the school that he did in fact have average intelligence, but he did have those disabilities, and was found to also be an anxious kid who was socially immature. When I interviewed his guidance counselor and the special ed director, they said in his senior year, he was functioning at about the level of a 7th grader, academically, emotionally, and socially. And I think that does have relevance to his ability to process information, make decisions, and his degree of impulsivity.
What did you find about Jimmy's judgment and decision-making capacity?
So, Your Honor, I found that Jimmy did know right from wrong. The problem was that when he would make decisions either in the moment, under pressure, he would be impulsive and not really think about any consequences or deliberation. He wasn't able to process the information that quickly, so he would just kind of go with whatever came to him.
Well, now, impulsiveness is sort of a classic trait of adolescence. What was different in this case?
It's true, it's typical of teenagers, but it's especially true of teenagers who have slow cognitive processing speed and have under heightened arousal, emotional arousal. They don't process even the way a normal adolescent would. So they're more vulnerable in those kinds of situations.
And how do you know that was true of Jimmy?
I looked at the psychological testing. I spoke with the classroom teacher about how he could function in there. And in my interview with him, when I would ask him questions, if he stopped and took a long time to think about it, he could put together a coherent, but if I said, you know, what about this? And he answered, he blurted something out, and then he would back off, and oftentimes just kind of like, I'd say, take your time, think about it. And when he did, he could come up with a reasonable answer to a question. So even in my own evaluation, it was clear to me that he needed the time to actually process something to get to an answer, make a decision.
So if he took his time, he was reasoned, but if he was immediate, he was often unreasonable. Sounds like witnesses on the stand, but go ahead.
I think that about his judgment, the other thing is that he was able to express to me in the interview that he had made bad decisions, particularly about the drug running, felt in tremendous pressure to both support his family. But the other thing that was really key in his history that I didn't mention to you, when he was 17 and a half, his dad found out from the neighbors, because it's a tight neighborhood, that he wasn't doing the odd jobs, that he was running drugs, pot, and other stuff for the local kids. And Dad also found out that he had an African-American girlfriend. And in an explosive outburst, he kicked him out of the house. Now, this was highly traumatic for Jimmy. He had no place to turn, and he went to Miss Brown's home, and she brought him in. I think that trauma was really difficult for him. As much as he felt anger and hatred towards his dad, he loved his dad, and he sought approval. He sought approval from everybody because he wasn't getting it from many places. And I think that colored some of his judgment. When he looked back, he felt that he should never have done the drug running, and I believe that. But he also expressed tremendous remorse for what happened the night of the robbery. I mean, he knew that he had severely, perhaps permanently, injured another individual, and that when I asked him specifically about that incident, and I also looked at the video, his story was that Tommy had said, there's this big cash collection at the convenience store, it's the end of the week, lottery was big, we're gonna do something a little different. We're gonna go, we'll back you up, and we're gonna go in there and we're gonna just take the cash and run. And according to Jimmy, they were moving towards the store, and at the last moment, he gave Jimmy a handgun. Jimmy had never used a firearm before, and he had no clue that that was gonna happen. And in the moment, it was, according to Jimmy, Tommy said, just go in there and scare this guy. Just scare him, and then we'll take it and we'll run. And that was bad judgment. And the events that happened, you understand that. And so he was terribly guilt-ridden about what had happened and about having made that really horrible decision.
Dr. Baer, were you able to make a risk assessment with respect to the issue of future dangerousness?
Yes.
And what is that assessment, and what is it based upon?
The assessment is based on past history of dangerous acts and through the interview and my evaluation of the whole context, a prediction of what might happen in the future.
Before you tell me your prediction, I remember there was a case before the Supreme Court of the United States about 15, 20 years ago in which the American Psychiatric Association put in a brief in which they said that their ability, the ability of psychiatry generally to make predictions about future dangerousness was little better, was only slightly better than chance. So have things changed that radically, that one can have confidence in this prediction?
In specific situations, we can make reasonable predictions of future dangerousness.
Well, have you tested how accurate your predictions are?
Personally?
Yeah.
With Jimmy, no.
Well, not with Jimmy, but I mean, the test is, of course, whether of any prediction is whether it pans out, right?
One thing we do know is that when a kid has a conduct disorder because of frequent violent behavior, abusing the rights of others, lack of remorse, the prediction is pretty grim. When a kid like Jimmy, who's had no history of violent behavior, of being well-liked, of being well-behaved and loyal, and having been abused, it's a different situation.
So that's your prediction?
My prediction is that he's probably more dangerous to himself, because the likelihood is that given his clinical situation, he's at high risk for suicide, and he's at high risk for being in danger by other criminals in penitentiary of being harmed or being used by them for the same kind of purposes he was outside of the penitentiary. And frankly, I think that
Wouldn't that same risk also exist whether it was in prison or out of prison? Because he would still be, given his background, someone who might well be approached by drug dealers or the like, yes?
He would, unless he were in treatment. And I think the bottom line is that if Jimmy could receive appropriate psychiatric care with extensive counseling and including medications for his depression, I think that he is a kid that could be saved.
Now, as you may be aware, and perhaps regretfully, there's limited funds and limited availability for this kind of intensive treatment that you have in mind. Supposing it's just not there to be had, so to speak, what do we do then?
We do what we do every day, and that is we find any way possible to get him in treatment. And sometimes we have to be extremely creative. There are not a lot of child psychiatrists or psychologists available. There are programs that, if we're strong advocates, if Jimmy had a strong advocate, he could get services. With advocacy and hard work, the services can be gained, but it has to be very, very diligent and dutiful.
Thank you, Your Honor. I just have a few more questions.
Yes.
In making your risk assessment, did you review the videotape? And if so, what impact did it have on that assessment?
When I viewed the videotape, it occurred to me that one, he was highly aroused. His hands were shaking. And when he spun around, there wasn't time for him, given his processing difficulties, he couldn't have taken, in my view, taken aim and intentionally shot that gun. I think what happened was that he was startled, turned the gun, and it fired. He didn't intend to do it. He didn't take aim. He didn't pause. It just happened in an instant.
One last question, Your Honor. Did you have an opportunity to review Jimmy's pretrial detention institutional records and making your assessment of his potential risk?
I did.
And what did his pretrial detention records show?
No evidence of any misbehavior. No write-ups about breaking rules. Kind of a model prisoner.
I have no further questions. Thank you very much, Your Honor.
Just on that last point, if he's someone who could be easily victimized by other prisoners, why wouldn't they be using him to help themselves commit the kinds of crimes that prisoners commit within an institution, so that he wouldn't for very long be a model prisoner because of the way he was victimized?
I think that's a very high risk, Your Honor. And my hope would be is that wherever he goes, that he can have some rehabilitative services that would help protect him from that, because short of any treatment in penitentiary or rehab, he's at risk. He's at risk for the same kind of behavior.
All right. Thank you so much. You may step down.
With the exception of closing remarks, that would complete our presentation.
Yes, before we hear closing remarks, my understanding is that there is a victim impact statement that the government wishes to read.
That's right, Your Honor.
All right, so let's do that now, and then we'll hear closing remarks.
All right, thank you very much.
Your Honor, one of the primary victims of the crime, Mr. Al Laz, would like to address the court.
All right.
Your Honor, I just want to tell you and share with the court the impact that of the actions of the defendant had on my family, on my wife, that he had gunned down a life that will never be the same. Let me tell you a little bit about us and about Cherie, my wife. We met 17 years ago when she first walked into the store. We looked at each other and we knew right away that we were to be married someday. We got married a few years later in a beautiful garden like she wanted. And we struggled for a couple of years to have kids. Cherie was determined. She wanted to be a mother. And now we're blessed with a 4-year-old son and 2.5-year-old daughter. Since April 4th, Cherie has been lying in bed in the hospital with a serious brain injury. She opened her eyes. Sometimes I feel like she doesn't know what happened to her, although I see a lot of sadness in her eyes. She doesn't recognize the kids, and the doctor advised not to have the kids visit with her for a while now. Cherie loved to travel. She loved shopping, hanging out with friends. She was not just my wife, she was my best friend. She was my life, and I miss her very much. Yesterday, my 2.5-year-old daughter said to me, "I'm done waiting, I need mommy now." And I didn't know what to tell her.
What does the doctor say is the prognosis?
I don't know what is the process of her recovery and how long that will take. But I can tell you that she is never going to be back the way she used to be before April 4th. I personally don't sleep much, and when I do, I have nightmares. I feel very disappointed that I failed to protect her. Although watching the video over and over, there was no way I could have prevented it. I constantly look over my shoulder, thinking somebody will attack me any moment. And it's been taking toll on me and the kids. And every day now I take the kids to school, I go to work, and I go visit with Cherie. My daughter used to be on 3 half days in school, and now I have to send her every day of the week for a full day. Instead of being with her mother, she's with her school teacher. I know Cherie wanted the best for our family. She had so much love. She will never be able to read stories, sing lullabies, take the kids to the beach. And, Your Honor, I want to ask you to punish this man who did this to us to the fullest extent of the law. Because my family is broken. We will never be complete again. Cherie is still lying in the hospital. Thank you so much.
Thank you. I think we're ready to hear argument of counsel. I remind counsel, as you're well aware, that under the law of this jurisdiction, each of these 2 crimes of which the defendant was convicted, armed robbery and aggravated assault, carry sentences of anywhere from probation all the way up to 25 years in prison. He was acquitted, of course, of the attempted murder charge, which would have carried up to life in prison. So the court has a very broad range here. Since the sentences could be either concurrent or consecutive, I'm confronted with a possible sentence of anywhere from 0 to 50 years. So let me hear from defense counsel, then from government counsel, and then from the defendant if he wishes to be heard. All right, Mr. Rico.
You know, Your Honor, it's been said that sentencing is probably perhaps the most difficult thing for a judge to do. In my years of practicing, my experience has been that the court has to find that balance between the convicted conduct and fulfilling the statutory goals that have been set forth in the sentencing statutes. But sentencing always provides the court with an opportunity to learn something about the defendant, to learn something about his or her life, and to try to find that sentence that's sufficient but not greater than necessary to reach the overall goals. And in this case, what we tried to do at sentencing was to give the court an insight into the mindset of this very young offender. Now, a long time ago, when I first started practicing law, I appeared in front of a now retired and deceased judge who said to me, Mr. Rico, the first step towards rehabilitation is recognition that a person made a mistake, that some wrong was done. And throughout this trial, I know Your Honor has paid very close attention to Jimmy. And at the one time in which he shed a tear in this case was not when the conversation was about himself or his family or his background, but when Mr. Al Laz was speaking about his wife. That was a reflection of his sense of a recognition of the damage that was caused by his actions on that night. And I think it was sincere. Everything that we know about Jimmy is that he is not intuitively a dangerous, violent person, that he is young, he is impulsive, a follower, a condition that disables most young people. Most young people have it. Jimmy's problem was complicated by a diagnosis of clinical depression, and the last thing in the world that he needed to be doing was using cocaine. You know, Judge, it's always difficult to find where that point should be drawn. There is no question that punishment has to be imposed in this case. But I would ask the court to look really hard at this case. I would ask the court to take a look at the video again, to take a look at the various reports that were submitted, the impression of Miss Brown, that's Miss Hope Brown, by the way, not Melodie Brown, and to see what a parent had to say about Jimmy. Ms. Brown was unique. As she shared with the court, you know, she got her degree the old-fashioned way. It took her 8 years to do it. She was a working mom. The kind of insight that the court can have confidence that's really coming from a perspective that's needed. And that perspective is, who is Jimmy? How did he get here? And what needs to be done here? Ms. Renita Jane, the drug counselor, was so struck by his need for help that she volunteered her time to work with him and to try to get him into a place where he could get help. Dr. Baer was able to give us a very important sense of the likelihood of violence in the future by Jimmy. And I would agree with the court that there's no scientific formula that can prescribe future dangerousness. But if we look back over Jimmy's life, if we look back over the circumstances that brought him into the deli on this day, we see a young man whose record is absolutely free of aggressive, violent conduct. No outbursts at school, no fighting with other kids. But what we do know is that he was a young man struggling to find love, struggling to find acceptance, and it ended tragically for him, tragically for the victims. You know, Judge, we can never undo the damage that was done. There's nothing that I could say, there's nothing that Jimmy can say, there's nothing that Mr. Ken can say that could take back the pain felt by the Al Laz family, the children of the family, can never take it back. But what we can do is that we can begin to be a part of a process that constructs a life. This court has tremendous power. I've seen it over the years. Tremendous discretion, and to utilize that discretion in the right case with the right defendant. The right case means where discretion is needed, because on the face of it, a very severe sentence is called for. The right defendant is a person who's capable of redemption. And everything that we know about young Jimmy is that, Judge, he is a young man who is capable of redemption. Now, whether or not he reaches that goal, well, that's going to be on him. He's going to have to walk the walk. But this court has the discretion and the power to impose a sentence that won't debilitate his life. Judge, I've always been concerned about the sentences that are imposed on teenagers. Lengthy sentences for teenagers, we've seen the results of that. They're at the bottom of the food chain in the penitentiaries. Defendants who are young are at the bottom of the food chain, and defendants who are young with psychiatric problems are walking around those facilities with bullseyes on them. All the statistics show that they're the victims of abuse, they're the victims of manipulation in prison settings. What I would say to the court is that that doesn't free a defendant from responsibility, but it certainly gives the court a moment to think about, where's this young person going? Do they have capability? Were I to exercise some leniency, can this defendant benefit from it? And that's where Ms. Brown and the other experts come in, and that's the reason why we called them in the first place. And that is to give the court an insight that Jimmy's got the capability. With the right parenting, with the right direction, with the right guidance, he can get there. His institutional record, since he's been incarcerated, has said he minimally knows how to avoid the wrong crowd in jail. Not an easy task, especially for a young offender, but it can be done. So, Your Honor, what I would ask the court is to consider all of those factors. I've appeared before Your Honor on sentences in the past, and I know that the court takes every single one of these factors to heart and really struggles with finding that right place. We can't forget, Judge, as tremendous, as terrible as this crime was, Jimmy Moran is a first-time offender. He was peddling the drugs, but according to Tommy Quinn, drugs without violence. We know that he's a first-time offender without a history of violence. And I'm asking the court to really consider that factor in imposing a sentence here that would be necessary as a corrective means for Jimmy. I'm asking this court to consider his background and circumstances as a means of determining whether or not there's a likelihood of redemption were the court to exercise its discretion and exercise leniency in sentencing. It's my hope that the court would. I believe that this young offender is a young man worthy of this court's consideration of those factors. Thank you very much, Your Honor.
Thank you. Let me hear now from the government.
Thank you, Your Honor. I think Mr. Rico had it right on. The point of the sentencing hearing today is to learn something about the defendant, to give it a little insight here. And we've heard now from a drug counselor and a psychiatrist and Ms. Hope Brown. But what you've heard from them is merely a sliver of it. I think Ms. Hope Brown put it best in her own words. When asked about the crime, her words, "Not the Jimmy I know." There's an entire side of Jimmy that these three people that you've heard from today, it wasn't reflected here, and yet I think what speaks to who the real Jimmy is, and a substantial portion of who the defendant is is the crime. And I think, as this court well knows, the nature of the crime is an important consideration at sentencing. And I think the nature of this particular crime not only speaks to the sentence that is demanded here, but also as to who is this defendant. This is a terribly violent crime, and this is a crime that had tremendous consequences to its victims. I can't even try to put into words how the defendant's actions destroyed a family. The court has heard from Mr. Al Laz in a very moving and stirring way. The lives of that family have been impacted forever, and I think the court needs to take that into consideration. But when you also then look at this crime, you have to know, as we've heard at trial, this was planned out. The defendant may not have been necessarily planning to shoot anybody that day, but he was prepared to do so. It was he who brought the gun there. It was he who could have run away or done anything else when Mrs. Al Laz came out into the store, but he shot her instead. And I think that speaks to who he is. Which actually makes me move on to the next point, Your Honor, which is basically the personal characteristics of the defendant, because I think the court has to look at the crime as well as who is this defendant. And I think there's one common theme that the court has been hearing over and over again today, is that he is young. But let's talk about that, because I don't believe, and I submit that in fact his youth is not necessarily mitigating. In fact, in many respects is aggravating, at least in terms of a more severe sentence here. First of all, his crime was serious. It was an adult in nature. It was not that of a juvenile. Also, if there's one thing that we've heard from the psychiatrist who had many hours to evaluate him, has looked at the defendant's background, the one thing that we've heard is that this defendant is young, and because he's young, he is especially impulsive. Not just impulsive like ordinary youth or ordinary adolescents, but especially impulsive and unable to control his actions. And because he's young, he is unable to control his aggravated impulsivity for even longer, which I think counsels then in favor of a longer sentence, because this court, as this court well knows, what you need to consider is protecting this public. To protect the public, a longer sentence is necessary from an individual like the defendant here who cannot control his impulses. In fact, I think as the court pointed out earlier, psychiatrists cannot with any certainty predict his dangerousness. So the only way really to protect the public and also to get the type of treatment, in fact, for the defendant is in custody, where he could have counseling. All of these services are available, as the court well knows, while he would be incarcerated. And I think also the psychiatrist talked about the fact that Jimmy's also a harm to himself. He is less a harm to himself while in custody under the care of the prison system. And finally, I move on to the last point, Your Honor, because at the end of the day, it is what is a just punishment here? And I think in doing that, you have to look at the harm that was caused, the measure of harm. Ms. Al Laz is never able again to walk, and her family is forever changed. And I think the sentence that this court imposes needs to give some measure of comfort and some measure of peace to the victims. As you heard from Mr. Al Laz, he has requested that this court punish the defendant to the fullest extent of the law. And I would submit, Your Honor, that a lengthier sentence is necessary here to reflect the severity of the defendant's conduct, to protect society from his impulsivity, and to be just here.
Thank you very much. Does the defendant wish to make a statement?
Yes, I do. Your Honor, I guess it's part of your job to be told how sorry people are. So I've been thinking about what else I can tell you, and I thought that I could tell you a little bit about what this experience has been like for me. The time I was arrested and brought into custody, it felt like another step downward in the way that my life had been going. I've been a bad kid my whole life. Drugs, not a good kid in school. It's always been a part of it and seemed like another step down that road, and sometimes I felt like that was the only road that was available for me. But arriving here, I met Mr. Rico, and I heard from Melodie and her mom, Miss Jane, Dr. Bear. They were on my side. I guess for the first time in my life, it felt like people believed in me, believed that I could not be like that anymore. And for the first time in my life, I believed that it could happen. I am sorry. Not a day goes by I don't think about what happened to Mr. Al Laz and his wife. And I know that I'm guilty and I'm responsible for what happened, and that's why I'm sorry. And I can only hope that you take into account that I feel like, and other people feel like I have something to live for. So please be lenient to me when you consider your sentence. Thank you.
Thanks very much. All right, the court is prepared to impose sentence. Defense counsel pointed out rightly that all judges view sentencing as by far the most difficult part of their job, because there you have in your hands the future of a fellow human being, and none of us has such wisdom, such learning, such ability that we can forecast the future accurately or be certain of our own views of punishment. And yet here we are with all our own frailties being called upon to, in a very real sense, determine the future of another person. It is a humbling task, and I claim no special ability or expertise in undertaking this difficult duty. Now, the sentencing laws speak in part in terms of abstractions like general deterrence and specific deterrence and rehabilitation. And these are all important factors that the court needs to take account of. But as with all abstractions, they give very little feel for the particulars of the case. There are so many individual factors that go into any sentence, and the notion that they can be expressed through a few abstractions is to deny the reality of the situation. And I do not propose to make the defendant a martyr to abstractions. What is important in this court's view are the facts, most particularly the facts of who Mr. Moran is and the facts of what was the crime he committed. And certainly, we don't find out much about who Mr. Moran is at the time of trial. The focus then is on the facts of the crime committed. The jury found, and in this court's view, though it is the jury's job and not mine, I think they found correctly that Mr. Moran was guilty of armed robbery, and what has been the focus of so much of the discussion today, he was also guilty of aggravated assault, but he was not guilty of attempted murder. And the difference between aggravated assault and attempted murder as applied to the facts of this case is essentially a difference of intent. At no time did Mr. Moran intend, in the normal sense of that word, to murder the victim, but as the jury found, he well knew that he ran the risk of something awful happening, and something awful, in fact, did happen. That's what we know about the facts. It wasn't until the sentencing hearing, though, that we began to know something about Mr. Moran. Oh, a little bit came out at trial, but much more so, and I am very grateful to the three defense witnesses who testified, all of whom were very impressive in their various ways. I have to mitigate what they say a little bit because they are all caretakers in their minds and hearts. They want to see a vulnerable person like Mr. Moran be treated in the most sensitive and positive and lenient fashion, because that's part of their whole view, not only of their professions, whether their profession is a drug counselor or a child psychologist or being a mother, but it's also part of who they are. But that, to be balanced about it, means that they see things somewhat through a particular lens that doesn't perhaps convey the whole picture as the prosecutor brought out. I mean, an example of this, not perhaps so critical, but just to give it, is that at trial, the younger Miss Brown, who I think shares with her mother a full heart and a full sympathy, blatantly perjured herself, in my opinion. I don't say that as a condemnation, but just as an assessment of her credibility, because she felt so strongly in love with the defendant and didn't want to see him convicted. Now, and that shows, if you will, the lengths to which in extreme cases sympathy can blind one to the realities of the situation. But having said that, I think that the witnesses I heard from today have convinced the court that this defendant is far from a hardened criminal, that his record is one that suggests that he is not someone society should write off or lose hope in altogether. And that while I'm very skeptical of the ability of psychiatrists, drug counselors, or judges to predict very far into the future, that it seems reasonable to assume that prison will not be a good learning experience for Mr. Moran. And yet, as even very able defense counsel recognizes, some prison has to be imposed here. Some substantial prison, perhaps. And why is that? Well, partly it is another abstraction, but one, I think, very central to civilized society, which is the vindication of the moral order. A crime of this magnitude simply cannot go unpunished, punished in a way that everyone recognizes as punishment. But there's something more immediate, and that is the terrible thing that has happened to the victim of this crime, the victims, for it's the whole family. But you talk about imprisonment. Right now, the woman that Mr. Moran shot point blank in the head is like a prisoner in her own body, unable to move, unable to communicate, unable to recognize her own children. This could continue indefinitely. No one has offered a prognosis that indicates how long it will be till she begins to recover, if at all. She is imprisoned in the most cruel way, and she is imprisoned in that way because of the reckless, knowing, intentional acts of the defendant. That cannot be blinked. That is what happened here. And it would be a denial of reality, a denial of what this world is all about, not to visit that terrible crime with a substantial punishment. So, the sentence of the court is that the defendant is sentenced to 12 years in prison. That is far less than I think many judges would impose in this situation. I am guided by the point made by defense counsel, which is also reflected in the statutes of this jurisdiction, that the sentence should be no more than is necessary than to fulfill the various purposes of sentencing. The sentence will be concurrent on both counts and will be followed by 5 years probation on the standard terms. And in addition, I will add the special condition that the defendant participate in a mental health program. To the extent that there's mental health treatment available within the prison system, which is sparse and limited, I would also recommend the defendant be permitted to participate in such programs. But the reality is, as Dr. Baer pointed out, is we don't offer really very much in that regard. I am also going to recommend that he be placed in a moderate security prison rather than a high security prison. This is a decision that will be made by the Bureau of Prisons. I can only recommend, but it seems to me that the type of inmate that the defendant will meet in a moderate security prison, while perhaps not the salt of the earth, will nevertheless be far better company in terms of his development than the psychopaths who regretfully form a very substantial portion of the population of our high security prisons. So, before I advise the defendant of his right of appeal, is there anything else that either counsel wishes to raise with the court? Anything from the government?
No, Your Honor.
Anything from defense counsel?
No, sir.
Mr. Moran, you have a right to appeal the sentence, and if you are going to appeal the sentence and the conviction, if you are going to appeal, you need to file your notice of appeal promptly. You understand that?
I do.
And if you can't afford counsel for the appeal, the court will appoint one for you free of charge. Do you understand that?
Yes, I do.
Very good. This matter is adjourned.